Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. First thing I want to say is thank you. I haven't posted much in 2 weeks because I've been working on these written submissions, and you guys have been nothing but supportive, so I really appreciate that. I've really had to devote my maximum attention to these things because this is a really important case. It'll have huge impacts for gun owners across Canada, and I'm hoping I'll win, so it'll be a positive impact, because the impact, if we don't win, is going to be very negative. As I've said before, I think this is a case that will ultimately end up at the Supreme Court. And when you expect a case to go that far, it's really important that you have a good foundation at the lowest levels here at provincial court. So that's taken a lot of attention. There's me and there's another lawyer representing some other applicants. And we're up against the sort of full financial resources of the government of Canada. We're the underdogs in this one. So I really appreciate that you guys have been supportive, and I'm here fighting for you even if I'm not making videos. That said, I want to move on and talk about a recent promise that the Liberal Party has made. They've promised three things, and I want to sort of assess them and see if they're necessary or not. So the promises are, first, that they want to make it a criminal offense to obstruct access to any building providing health services, including hospitals, vaccine clinics, testing centers, pharmacies, and abortion clinics. Next, they want to protect healthcare workers by making it a criminal offense to intimidate or threaten any healthcare professional carrying out their professional duties providing medical care or Canadians receiving that care. And next is they want to ensure every business and organization that decides to require a proof of vaccination from employees or customers can do so without fear of a legal challenge. So I'm going to talk about these, I guess, in reverse order. And the reason why I'm going to do that is I'm going to start out with the one about businesses because I am not a labor lawyer and I'm not really a civil lawyer, so I can't really dig into the law on this one. That said, there are a few things that really concern me here. When they say without fear of a legal challenge, that sounds like you're removing this from something the courts can look at. And that always concerns me. If you're providing a broad-scale immunity, well, you need the courts to supervise because there's always edge cases. There's always scenarios where people might be abusing a law or where they might be engaging in discriminatory practice using that law as cover, or you might be talking about unusual edge cases. So some examples here that, sort of leap out is, let's say you've got somebody where there's no reason to require proof of vaccination. Let's say they live overseas and work remotely. Does it make sense to be able to say that worker who never comes into the office, we need to demand proof of vaccination from that worker? Especially if they live in a country where perhaps vaccination might not be accessible, if a less wealthy country, for instance. Also demanding, there are some people who may need a medical exception. The one I've seen mentioned is if you go in and you have a really strong, perhaps life-threatening allergic reaction to your first shot, your doctor might tell you not to get a second one. Well, that seems like something that the courts might have to work out and say, listen, this person might have a legitimate medical issue, and so maybe you should find some way to accommodate them instead of just firing them. These are the sorts of questions that we have courts for. This is what the rule of law is all about, that you can air your grievances and have them decided by an independent, neutral arbiter. If we're saying that that's not available, that's concerning. The other thing is when they're saying this to customers, because, for instance, this proof of vaccination might be used as a way to exclude people of particular racial groups, of particular economic groups. If you're the manager of a McDonald's and you want to kick out homeless people, you might just say, hey, we need to see your vaccination cards. So I'm worried about these abuses, and I'm worried about whether or not providing a blanket immunity is going to end up causing some serious problems. I get concerned about that sort of thing. That said, I'm not a labor lawyer. I'm not an employment lawyer. I just know that bosses don't necessarily always have your best interests at heart, and sometimes they get up to shenanigans. So I'm concerned that this might provide some protection. Of course, I can only say might at this stage because we don't know what the actual law is going to look like. That said, I want to go on and really talk more about the other 2 points because those are really touching on criminal law here. So they say protect healthcare workers by making it a criminal offense to intimidate or threaten any healthcare professional carrying out their professional duties, providing medical care, or Canadians receiving that care. Now, when they say making it a criminal offense, that sounds like it's not a criminal offense already, right? And I've seen a lot of people commenting online saying, wait a minute, why isn't that a criminal offense? Well, the answer is that it already is. And the reason why is because it's actually illegal to threaten anyone. Let's have a look at what the law says. So, uttering threats. Everyone commits an offense who, in any manner, knowingly utters, conveys, or causes any person to receive a threat, A, to cause death or bodily harm to any person, or B, to burn, destroy, or damage real or personal property, or C, to kill, poison, or injure an animal or bird that is the property of any person. That seems to cover a pretty wide range of threats. If you're threatening to do pretty much anything, then you're probably going to fall under the uttering threats. And that has a maximum penalty here of 5 years. Seems to me 5 years in prison is probably more than enough to solve the issues on that one. So now it's not entirely clear because they don't specify what they mean by intimidates. But we can go and look at another offense that might apply here, and that is the offense of extortion. Extortion. Everyone commits extortion who, without reasonable justification or excuse, and with intent to obtain anything, by threats, accusations, menaces, or violence, induces or attempts to induce any person, whether or not he's the person threatened, accused, or menaced, or to whom violence is shown, to do anything or cause anything to be done. Now, if you commit extortion, you get to play for the big prize because the maximum penalty is life in prison. Now, there's no minimum normally, but if, for instance, you use a firearm in the commission of an offense, then that triggers a mandatory minimum of 4 years. There's a higher mandatory minimum if it's done at the direction of a criminal organization or involvement of or same. So extortion is an available charge if somebody is trying to intimidate somebody into doing something. Stay home from work or else we will do bad things to you. Well, they could lay a charge of extortion. So that is available to them. The notion that this is not something that's already punished by law, quite frankly, I don't see how we can support that. Do we have any other options in the toolbox? You bet we do. Intimidation, section 423. Everyone is guilty of an indictable offense and liable to imprisonment of a term of not more than 5 years, or is guilty of an offense punishable on summary conviction, who, wrongfully and without lawful authority, for the purpose of compelling another person to abstain from doing anything that he or she has a lawful right to do, or to do anything that he or she has a lawful right to abstain from doing, A, uses violence or threats of violence to that person or to their intimate partner or children, or injures the person's property, B, intimidates or attempts to intimidate that person or relative of that person by threats that, in Canada or elsewhere, violence or other injury will be done to or punishment inflicted on him or relative or of his or hers, or that the property of any of them will be damaged. C, persistently follows that person. D, hides any tools, clothes, or other property owned or used by that person, or deprives him or her of them, or hinders him or her in the use of them. Or E, with one or more other persons, follows that person in a disorderly manner on a highway. F, besets or watches the place where that person resides, works, carries on business, or happens to be, or blocks or obstructs a highway. Do you think that's an available set of tools here? Looks like there's another set of tools that they could already use for anybody who is intimidating somebody who works at a hospital. It's literally in the name of the section here. All right, carrying on. The next promise that they make here is they say, make it a criminal offense to obstruct access to any building providing health services, including hospitals, vaccine clinics, testing centers, pharmacies, and abortion clinics. And people have said, oh, well, that's not a criminal offense. Why is that not a criminal offense? To block somebody from going into a hospital, they could die. That's real serious. Well, once again, let's have a look at what the criminal code says about this, because as it turns out, there's already an offense that covers this. So, mischief. And mischief doesn't sound like much, and mischief is this incredibly broad offense because it can cover all sorts of things. If you key somebody's car, that's a mischief, but mischief can go much, much further than that. So everyone commits mischief who willfully A, destroys or damages property. Not really our issue here, but it's relevant if somebody damages things at a pharmacy, for instance. Renders property dangerous, useless, inoperative, or ineffective. Maybe not so much. Obstructs, interrupts, or interferes with the lawful use, enjoyment, or operation of property, or obstructs, interrupts, or interferes with any person in the lawful use, enjoyment, or operation of property. So if you are obstructing somebody from going to a hospital, that sounds to me like a mischief. I don't see why they can't charge a mischief here. And in fact, there is prior case law where they have indeed not only charged mischief on these sorts of things, but where they have gotten convictions for mischief on these sorts of things. For example, the case of the Queen and McCann. Now, in this case, 3 people blocked a rail line that was leading out of a prison because they wanted to stop cattle from being moved out of that prison. Now, if you're wondering why were there cattle in prison, well, obviously they were convicted of murder. I'm kidding. They were there as part of a work farm project so that prisoners could help raise cattle and learn some useful skills. I've got some sympathy for the accused in this file because I think these work farm projects are a great thing. You can get people doing some real meaningful work, learning skills. It really helps with rehabilitation. And it also helps with maintaining order within the prison because when people actually have useful, meaningful things to do, they tend to get into less drugs. They tend to get into fewer fights. So I've got some real sympathy for these people, but notwithstanding that, they were convicted of mischief for blocking the rail line because you can't stop people from using the rail line. Now, the court does identify an exception here, which they didn't fall into. And it says, the trial judge provided a lengthy review of the defense arguments, including case law wherein accused persons were found not guilty of mischief charges in circumstances where the trier found that while the conduct may constitute mischief, it was peaceful, for political purposes, and intended to express a message, and therefore was within the limits of a tolerance of a free and democratic society. The trial judge rejected all arguments and rendered a conviction. That's in this particular case. So you might say, well, maybe they could close this little gap of where you can have peaceful for political purposes and intended to express a message such that overall it is within the limits of tolerance of a free and democratic society. Well, the problem is that this little gap, this opening here, is actually because we have charter rights to free expression. They can't really close that gap without invoking the notwithstanding clause or something else. There may be legitimate reasons to protest at some of these places. If you have, for instance, a pharmacy that has been involved in, selling under-the-counter date rape drugs, I could absolutely see people wanting to protest that, and quite frankly, that would be perfectly legitimate. So I think that there are, real concerns here if they're going to try to close this, or is this just going to be a useless law? Now, you might be saying, well, maybe they're going to up the punishment because, if somebody can't get into a hospital, then, they could die. Like, let's say they're blocking an ambulance, somebody's been stabbed or shot, or they've had a cardiac arrest, and that ambulance needs to get in there right now. You can't wait 2 minutes. Well, as it turns out, mischief already covers this. Because if we look at the punishment sections, punishment. Everyone who commits mischief that causes actual danger to life is guilty of an indictable offense and liable to imprisonment for life. So that's not a minimum, that's a maximum, but imprisonment for life. Again, you get to play for the big prize on this one. And nobody wants to play for the big prize. This is not a happy casino that, we're talking here. So it's very difficult for me to envision how we're going to punish this more than life in prison. Life in prison seems to me to be a pretty solid deterrent on this one, especially because I can't see, what else would they do here? Are they going to put in some mandatory minimum? Well, that mandatory minimum would probably get struck down by the court because there's always going to be some sort of exception. So I don't see what they're doing here. I don't see what their game plan is. Quite frankly, it seems like they are manipulating the public because they're suggesting that this is not illegal when there are already laws. And if you're saying, hey, we've got to do something, we got to get the police in there, they could get the police in there right now. Why isn't he doing that if this is such a big thing? Get the RCMP moving. But I guess he's got his reasons. But pretending that another law is going to fix the failure to enforce the ones we already have is just nuts. I really hate when they use laws like this for political purposes. Let's add another law. Well, how do you think our law got so messed up? Every time something unpopular happens, it's let's make another law, not let's maybe look and see if we could already use the ones we've got. Anyway, that's my commentary on that. I've got some other things in the works. I think some of them I've mentioned on Twitter, but stay tuned. As I said, I'm hoping to be back in action, posting more regularly again. And once again, I really thank you guys for your support. Please like this video. Please share it with your friends. Please subscribe to see more content. I'm pretty sure YouTube will have said, hey, this guy hasn't posted anything in 2 weeks, so maybe his channel's dead. So some activity would be really helpful here. Let them know that, we're still here. We haven't gone away. I also want to thank my Patreon supporters. I also feel kind of bad because, you guys have been supporting me, but fewer shout outs this month. I'm sorry. Let me know if you guys have issue with that, but hopefully not. Anyway, thank you at the $50 level, Jonathan Wheeler, Jason Elliott, Canada's National Firearms Association, Mike, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jane Babe and Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., and Andrew Elsich. Thank you as well to everyone at the $10 level who will be in the crawl immediately following. Thank you, and I hope this has armed you with knowledge. As I said, I've got some backlog, some things I've been wanting to talk about, but I've just been too busy. So let's get to it. Anyway, see you next time.